talk about scandalous and disparaging marks. Marks that are immoral, deceptive, or scandalous matter, or matter which may disparage persons living or dead, institutions, beliefs, or national symbols may be refused under Section 2A of the Lanham Act. Think about the controversies related to Native American mascots in sports, such as the Washington Redskins in the National Football League. In 1992, Native American groups filed a cancellation action on that mark, and in 1999, the USPTO canceled the Redskins registration. The District Court in the District of Columbia reversed, saying there was not enough evidence of disparagement. Later, other courts held that other challenges were untimely. While another case involving the Redskins trademark and Native Americans was pending, the United States Supreme Court heard a case called Mattel v. Tam. In this case, a band consisting of people of Asian descent had a band named Slants with the purpose of taking the stigma away from the word. The PTO denied trademark registration, saying that it was disparaging against persons of Asian descent. The TTAB affirmed. The Federal Circuit affirmed. The Federal Circuit en banc found that the decision to deny registration violated the First Amendment. On appeal, in 2017, the United States Supreme Court held that the prohibition in Section 2A of the Lanham Act for disparaging marks violated the First Amendment, which deals with the freedom of speech here in the United States. It is not up to the government to decide what is offensive. It was an 8-0 decision, with Justice Gorsuch not taking part in the case. Interestingly, despite decades of fighting for its trademark rights, the Washington Redskins rebranded as the Washington Football Team in 2020 and 2021, and are now the Washington Commanders. So, even though they had now had the right to use the name, public tide had shifted such that they voluntarily gave up using the name. Another example of voluntarily giving up a potentially disparaging name is the Cleveland Indians of Major League Baseball. They rebranded as the Cleveland Guardians, which created additional controversy. As another example, there have been at least 4 applications with the USPTO for COVIDiots, a combination of COVID-19 and idiots. The USPTO issued office actions related to failure to function and raised the possibility of ornamentality issues, topics for a future vlog. If the Supreme Court hadn't ruled the way it did in Mattel v. Tam, I wonder if there would have been grounds for refusal based on being disparaging or scandalous. On the international level, under the European Union trademark regulation, trademarks which are contrary to public policy or to accepted principles of morality cannot be registered. There is some concern that this test is vague. The International Trademark Association, or INTA, is arguing for a new test that prohibits marks that are immoral according to the majority of the relevant public. Neither of these would probably survive under the United States' First Amendment protections. So, let me know what you think in the comments below. And remember, trademarks are fun.